Right, let's start with the general introduction to the nature and purpose of expert evidence. Open up our materials and let's go to presentation mode. The role of expert witnesses in administering justice is becoming increasingly important. The expert witness, once an infrequent visitor to the courts, now enjoys a daily presence. I remember this. I remember that 25, 30 years ago, when you went to court with an expert witness, or you encountered an expert witness, it was slightly unusual. And it was quite a big, unusual type of case with a lot of preparation. The preparation of the expert and the preparation for trial were both quite intense. Over the years, that's changed. We now have experts every single day. You go to trial courts, there are experts involved. They become integral to the administration of justice and a very important role player in the teams of both the plaintiff and the defendant. But with that has also come a body of principles that has grown up around the appearance of experts in the courts. And it's really, that's what we're going to address in this course. So let's start off right at the beginning, and we have a look at, yes, expert witnesses are now more frequent visitors to the courts. We've got a body of principles that have emerged. And let's have a look at what the courts have said about I think it's not meant to be anything more than just general thoughts about why this is the case. But in the matter, you'll see at footnote 2, Twine versus Naidu, the judge said the following: two broad reasons have been identified for this. One, litigation has undergone an unprecedented growth over the last few decades. That's certainly true in personal injury work, and the way that from the 1980s to present, there's certainly been a change and there's an increase in volume, most certainly. And then over the same period, the growth and development of scientific and technical knowledge of the natural, physical, social, and commercial world has been vast. So there's been this growth. I think the technology also plays a role here. It feels as the information, we're sort of in the information age. There's a lot of information available. How do you use all that information? How do you make it available to courts? All of that is important. And then the comment goes on to say, this has often resulted in the law being forced to play catch-up. The courts have remarked that the prevalence of expert testimony has produced challenges for the courts, some of which are fundamental to the duties and functions of the courts in administering justice. This ties into the earlier point, doesn't it? So as we have more experts appearing and as expert witnesses take their own right as medico-legal professionals and play an increasing role in cases, and often a decisive role, either when a case is settled or when it goes on trial. The expert witnesses is often the deciding factor between those two parties, and then the way the expert witness is managed and the opposite side's expert witnesses is managed and dealt with. And then in Twine versus Naidu, at paragraph 18, the court held, most of the challenges faced by the court arise from the fact that the basic principles about the role, relevance, and value of an expert's testimony are often ignored by the alleged experts themselves and by the parties calling them. This, unfortunately, has resulted in the unnecessary wastage of court time and the unnecessary incurrence of costs by parties. It is for this reason necessary to recall the basic principles involved in the admission of expert evidence. Now, this course, in a sense, is aimed at addressing that very point. In other words, it's there to go over the fundamental principles of being an expert, preparing an expert, dealing with experts, either as legal representatives or as expert witnesses, of course. Let's turn then to the next topic.